Hello students, welcome to Darasa Online. So today we have a revision on commerce subject on the topic known as business units with a subtopic dissolution of business units. So our main topic is business units. And our subtopic is dissolution of business units. So by dissolution of business units, here we mean when business units comes to an end. It means business units have life. So sometimes these business units may come to an end. So this is what we call dissolution. When any business unit, being a company or sole proprietorship, partnership, comes to an end. And this is what we call dissolution. So with this revision, we will cover the following areas, or we cover the dissolution of the following business units. Areas to be covered. Number one is dissolution of sole proprietorship, sole proprietorship. Number two is dissolution of partnership. Number three is dissolution of companies. And number four, dissolution of cooperatives. So these are the areas to be covered for this revision. Now let's start with dissolution of sole trade or sole proprietorship. Sole proprietorship. Now, sole proprietorship is the business unit which is owned by a single person. So this one, loss of the business or the profit of the business is for a one person. So the person takes all the profit of the business, but also this person will be responsible for the loss of the business, but also the one who contributes the capital or the one who provides the capital for the business. Now this business may come to an end with the following reasons. Now number one is by voluntary decision. So sometimes a sole trader or a sole proprietor may decide to stop or to end up or to wind up the business voluntarily. Maybe he may decide or she may decide to start another business. So he may end up that business which he has been doing and then start another business. He may just decide to stop business and just keep on doing other activities. Another reason is illegal business. When the business is found doing illegal business, automatically this business will be stopped or will by the authorities be stopped operating. For example, when the business is caught dealing with, in Tanzania, for example, drugs is illegal. So when a business is caught conducting an illegal business, then authorities or the government will end up such a business, and therefore that business comes to an end or that business will dissolve. Another reason is death of a sole proprietor may cause or will cause an end to the business. So most of these business, sole proprietorship, when the owner dies, then most of these business also die. Because those people who may inherit the business may lack some skills which may cause that business to collapse or to dissolve. So most of the time when owners die, these business also die or dissolve. When the owner dies, then most of the business dissolve or comes to an end. Another reason is by an outright sale of the business to another proprietor. So when the owner decides to sell his business to another businessman or to another proprietor, then the business which has been operating now comes to an end. Comes to an end in the way that the owner now has sold the business to another businessman. So that business stopped to operate in the name of the previous proprietor. Now this business goes to another proprietor or to another businessman. Another reason is bankruptcy. So when the law approved that this sole proprietor has undergone bankruptcy, so automatically the business will come to an end. Now, it's not just a matter of saying that now you are bankrupt. There are some procedures which must be followed to approve that this man or this business, this man has undergone the bankruptcy. So there are some procedures to approve that you are bankrupt. Another reason for dissolution of sole proprietorship is by admission of a part or a partner. So when a businessman or when a sole proprietor admit or allow another person to join the business, now this businessman has to value his business, to show the value of the business, so that when this man comes, they start afresh. So the process here is, the business should come to an end, then they start with this new man who is coming to join the business, and then they start afresh a new business. Then the previous business come to an end, then they start a new business. So these are the reasons for a sole proprietorship dissolution, or reasons for which may cause a sole proprietor to come to an end. Now after this, let's come to Dissolution of partnership. Now, partnership business is a type of business where two or more people come together and they contribute capital for the aim of doing a business for a profit. So here there must be two or more people who comes together and then they operate a business for the aim of getting profit. So partnership also, or partnership business may come to an end due to the following reasons. There are reasons which may cause partnership business to come to an end. So let's have a vision on these reasons in which partnership may come to an end. Now the following are the reasons. Number one is dissolution by consent. Now this by consent, dissolution by consent here, by consent, we mean that our partnership, all partners have agreed to end up the business. They have come into an agreement that they should wind up or end up the business. They agree, all of them, they must agree. All partners must agree to wind up the business. And then the business comes to an end. It's not a matter of just one partner who is in need to end up the business. It's a matter of all partners comes into agreement to wind up or to end up the business. Or in this one, also it can be a matter of expire of time. Sometimes a partnership business can be formed for a specific time. Partners may form a business, let's say for 5 years. So when that time passes away, then the business will come to an end. Or sometimes partnership may be formed with the purpose of completion a certain work. So when that work is completed, then partnership will come to an end. So this is an agreement. Either the agreement was done before, that after 5 years, then partnership comes to an end. Or after completing this work, now this business will come to an end. Or they may agree after the formation of partnership. Number two is contingent dissolution. Under contingent dissolution, sometimes when an event happens like death, so partnership will come to an end. When any partner dies, either it may be 10 of you partners, but when one of you dies, then automatically that partnership must come to an end. Or when one of partners are gone insolvent or bankrupt, then partnership will come to an end. So the contingent dissolution here, it means when one of two events happen, death, then partnership must come to an end. Or when one of the partner is approved to be insolvent or bankrupt, then automatically partnership must come to an end. Another reason is dissolution by notice. Now with this one, dissolution by notice is when either one of the partners give a note in writing to another partners showing his intention of dissolving a partnership, then when that decision is in writing, then automatically partnership will come to an end. So my dear students, something to note here: dissolution by notice. A partner who wishes to end up the partnership business must give these notes in writing. It's not a matter of just saying using words of mouth. You must put this in writing, and this will be as an evidence. So it's a document which must be kept. So that's why a written document is needed. It's not just a matter of just saying that I need to dissolve partnership. If you are in need of this dissolving a partnership as a partner, you must notify other partners in writing. Another reason is compulsory dissolution. Under this one, as I've said before, under compulsory dissolution, partnership number, the minimum number of partnership is 2. So partners must be, in order to form a partnership, there must be 2 and above partners. So when it's happened that partnership, members of partnership, there is only 1 member in partnership, then automatically that partnership must come to an end. Partnership Act provides that partnership minimum number must be 2. So when it's happened that there is only 1 partner who has remained in partnership, then automatically this business or this partnership business must come to an end. Another way in which partnership may come to an end is dissolution by court order. Under this one, it may happen that one of the partners has got mental disability or mental problem, and he is not well in terms of making either decision or carrying the business or perform the duties in business. So when one of the partners become unsound mind, then automatically the business will come to an end. So the court may order a business to come to an end. Or when one of the partners is incapable of carrying out his or her duty in partnership. When that happens, for example, one of the partners, now he cannot perform anything. Maybe that partner has got an accident which may now cause him or her not perform anything in the partnership. Or when one of the partners has become so sick or has got a disease which make him not to be able to perform his obligations or duties in partnership. So in this situation, a court may order dissolution of such partnership. But also when a partner commits breach the conduct of his business, when one of the partner do something which is against the aims of the business, or when such a partner conducts an illegal issue which is contrary to the aims of the business, so the court may order that business to wind up or to come to an end. But also when the business is found doing illegal business, So the court will order such a business to wind up or to stop. So my dear students, these are the different ways and reasons in which a partnership may come to an end. So the business of partnership may come to an end in different ways and with different reasons. So just understand, a question may ask you to give different reasons in which a partnership business may come to an end. So these are some of the reasons or important reasons and ways in which a partnership business may come to an end. So after explaining this, then let's see how a company or how companies may come to an end or may wind up or may dissolve or may liquidate. So in companies, dissolution of companies, here you can say liquidation of companies. Or sometimes instead of saying dissolution, you can say liquidation of a company, or winding up of a company, or dissolution of a company. So these are alternative words which may be used to show that the company is coming to an end. So either liquidation of a company, or winding up of a company, or dissolution of a company. So all these words can be used to mean the same. So when you have a question asking you, what are the reasons for liquidation of a company, will be the same question with what are the reasons for winding up of a company, or will be the same question with what are the reasons for dissolution of a company. So my dear students, don't get confused. It means the same. So have these alternative words which mean the same. So dissolution of a company may come in the following ways and reasons. So dissolution of a company can be either compulsory liquidation or winding up by the court. So this compulsory liquidation or winding up is a must. It's not a decision which is decided or which is made by owners of the company. Now this is out of control of shareholders or owners of the company. Now this comes from the court. Now it's the court which gives an order of dissolution. Now this is what we call compulsory or is a must. It's not a matter of whether you like as shareholders or you don't like. Is a must, is an order of the court. Now what are the different reasons which may cause compulsory liquidation? Now reason number one is where the company is unable to pay its debts. So when the company is found not in a situation of paying its creditors, and the court has done investigation and found that that company will not be in a position of paying its debts, and the court see that that company to continue doing business will just accumulate some more debts. So the court may give an order of dissolution, or an order of winding up, or an order of liquidation. So when the company is unable and the court has approved or has proved beyond doubts that this company will not be able to pay its debts, so the court will give an order of liquidation or an order of winding up. Another reason is where the number of members reduced. For a private company, a minimum number is 2. Private company. For private company, a minimum number is 2. For public company, a minimum number is 7. So when it's happened that the number of private company is reduced below this, so assume it's 1. So this company must come to an end. According to Companies Act, it provides that the minimum number should be 2 for private company. And when you find that the number in public company is below 7, let's say 6, so this company also must come to an end. So this is by the law that a minimum number should be 2 for private company and 7 for public company. So when it's happened that the number is reduced below 2 for private company and below 7 for public company, then the law requires such a company to wind up. So this is a compulsory winding up. Another reason is when default made in the revealing the statutory report or holding the statutory meeting. Statutory report is a report which must be submitted. So when it's happened that the company has make a default on the revealing or submitting the statutory report or holding a statutory meeting, then automatically that company will be given a winding up order by the court. So companies are required, public companies are required to conduct a statutory meeting. A meeting must be conducted. Within a year you must conduct a meeting. This is required by law. But also you must prepare a report. And this one is financial reports must be prepared. So when it's happened that the company failed to conduct that meeting which is required by law, and the company has failed to prepare those reports, and therefore that company will be given an order of winding up by the court. So it's a must to submit or to hold such a meeting. Another reason is where the company has by special resolution resolved that the company be wound up by the court. So sometimes it may happen that a company has made an agreement that that company should wind up by the court. So when members or shareholders has agreed that the company must wind up by the court, then this one will be wound up by the court. But also, where the company does not commence business within a year from incorporation or suspend business for a whole year. Now, when it's happened that after getting a certificate of incorporation, after a company getting a certificate of incorporation, or after a company being registered, the law requires such a company to start a business within a year. So when it's happened that the year has passed and the company has not yet started a business, so this company will be wound up compulsorily. Or when it's happened that the business has suspended a business, the company has suspended a business for the whole year. So this company will be given a winding up order by the court. So when you're in a business and then you suspend a business for the whole year, so automatically this business will be given a winding up order. So this business must end up. This business does not qualify to continue with business. Because when you suspend the business for the whole year, so you will affect the society negatively. So assume that the society is depending much on your business, and then you suspend such a business, then automatically you're affecting the society. So that's why you are required by law not to suspend a business for the whole year. So when this happens, then the court will give you a winding up order because you have failed to operate your business. Another reason which may cause a compulsory dissolution or liquidation is where the court is of opinion that it is just and equitable that the company should be wound up. Sometimes the court may see the conduct of the business of that company, and the court may has an opinion that this company should wind up. For example, the court has discovered that that business is conducting an illegal business. So the court may give an order to stop such a business. So the court sometimes may make a decision basing on the conduct of a certain company, and the court decides to stop or to wind up or to liquidate such a company. So those are the different reasons, or these are the different reasons in which a company may be liquidated by the court order. All these are the reasons for compulsory liquidation. So when the court has satisfied that a certain company should wind up, then the court will give an order to the company to prepare a statement of affairs. Now this one will be a notice of 14 days. Now directors of the company should prepare a statement of affairs. Now this statement of affairs will show the liabilities of a company, the assets of a company, creditors of that company, and then after preparing such a document which shows the assets, liabilities, creditors of the company, and then that statement will be submitted to the official receiver. Now, an official receiver is the person who has been appointed by the court in order to pass through those documents which have been submitted by directors of a company which is now undergoing liquidation. Now, that official receiver will pass through and then prepare a report which will be submitted to the court. And then the court will pass through that report, and if there is something of fraud which was made either by directors or shareholders, then measures will be taken against those people who did such fraud. But also the court needs to know the reasons why the company has come to the situation of failing to pay creditors or to the situation of bankrupt, if that's the case. Then the court will appoint a liquidator. Now, a liquidator is the one who will supervise each and everything. Is the one who will be dealing with the selling of the assets of the company. Is the one who will be dealing with any issue regarding the company. So after that, all the assets will be sold by the liquidator, who will be supervising the process. Then creditors will be paid, and if anything remains, then will be distributed to shareholders. Now that is the end of compulsory liquidation. So my dear students, hope you are very okay with this one. So a question may ask you to explain the main reasons for compulsory liquidation. Because sometimes a company may be dissolved or liquidated or winding up compulsory, like this reason which you have explained here. But also sometimes a company may winding up in a way where shareholders decide by themselves. So this one is not compulsory. So it may be compulsory winding up, or sometimes it can be a voluntary winding up. So after having a vision on compulsory liquidation, now let's see another way in which a company may liquidate. Another way is having a company's name struck off the registrar. Now this is when the company has been in a mistake. Some mistake has been conducted where the registration has been improperly permitted, e.g. where after registration it is discovered that the objects of the company are illegal. So sometimes it may happen that there was improper registration. It has been discovered that after the company being registered, then it has discovered that the objectives or objects of the company are illegal. Then automatically the name of that company will be struck off from registration. So that name will be removed from registration. So it may happen that the registration was improper done. So after discovering that the objectives of that company are illegal, now this one has been discovered after registration, then automatically that name will be removed, so that company won't be registered again. So that's the way. Now another way is voluntary dissolution. Now with voluntary dissolution here, we mean that members themselves voluntary. Under this one, voluntary liquidation voluntary liquidation, it means members themselves, shareholders of the company, may decide to wind up the company, or to dissolve a company, or to liquidate a company. So under this one, we have members voluntary liquidation. Under this one, directors have to file declaration of solvency. So under members voluntary liquidation is when directors file the declaration of solvency. So under this situation is when directors believe that, and they are sure that the assets of the company, of the business, are enough to pay the creditors. So when assets available are enough to pay creditors, then this declaration of solvency, now this shows that the assets available are enough to pay all the creditors of the company. So under this one, then the company is dissolved in this way. But also sometimes under this voluntary dissolution is creditors voluntary liquidation. Under this one is when directors see the assets of the company that are not enough to pay creditors, and therefore creditors themselves will liquidate a company, because directors have seen the assets that are not enough, so they leave these to creditors. Now that's why it's called creditors voluntary liquidation. So members themselves decide to do this. But when assets are enough to pay debtors, then the directors have to file a declaration of solvency. But when assets are not enough to pay creditors, then creditors has to undergo the process. So these are two ways in which a voluntary dissolution can be done. Either members voluntary liquidation or creditors voluntary liquidation. And the main difference of these two is, under this one, member voluntary liquidation is when the company's assets are enough to pay creditors. Therefore, directors will issue a declaration, solvency. But when assets are not enough to pay creditors, then is known as creditors voluntary liquidation. So under this one, there are different reasons in which a company may come to an end voluntarily. Now, number one is if the period, if any, expire, or an event, if any, occurs. Now, sometimes a company may be formed for specific time. You may form a company, let's say for 5 years. So when that 5 years pass, then the company will come to an end. Or sometimes you may form a company to accomplish a certain event. So when that event occur or complete, then automatically the company comes to an end. This is voluntary. You decided. Members decided that. So number two is if a company resolved by extraordinary resolution to the effect that it cannot by its liability continue its business and that it is advisable to be wound up. So sometimes a company may see the trend of the business. Now members can see the trend of the business, that the business is having a lot of liabilities. And the members see that, or shareholders see that, continuing business, it won't help the business. It will just accumulate more liability to the business. The business is not in a good status. So when you see creditors or liabilities, the liability of the company has increased. So shareholders may pass an extraordinary resolution that the company should come to an end. So it's voluntary. Members themselves see the situation of the company. They see liabilities and see that the company is just accumulating liabilities and therefore may decide to wind up the business. Number three is if the company resolved by special resolution that the company be wound up voluntarily. Sometimes members may see the way the business is performing. The business is not making profits. The business has been making losses. So automatically members may may come together and make a decision that this business should wind up, or this company should wind up, because its performance is not something which is convincing. So these three reasons may cause, or are the causes for voluntary dissolution, or voluntary liquidation, or voluntary winding up. So my dear students, a question may ask you, either basing on compulsory liquidation or basing on voluntary liquidation. So just understand. Now, what are the reasons? You have to understand that what are the reasons for voluntary liquidation, and what are the reasons for compulsory liquidation. So when you are aware with those two scenarios, voluntary liquidation and compulsory liquidation, then you will be comfortable on answering any question regarding those two issues. Another way in which a company may come to an end is by order of the court without winding. Now, this is a situation where the act provides for the speedy dissolution of a company whose business has been acquired by another company. So it may happen that one business acquire another business. So assume that you have business A or company A. You have company A here, and you have company B here. So when it's happened that company A has acquired a business of company B, so here the act provides for speedy dissolution. Now this one should dissolve because the business of this company has been taken by company A. Assume this was called Dubai business. Assume it's Dubai business. Now Dubai business has been taken by Mwanja business. Mwanja business company. Mwanja company has taken Dubai business. So this one is thought to be called Dubai, and now the business may continue, but the name now will not be Dubai anymore. Now the name will be Mwanja, but the business may be operating. Assume is a manufacturing industry, Dubai. So it will continue with its business of manufacturing, but the name won't be Dubai. The name will be Mwanja. So dissolution is that had dissolved to be called Dubai, and now the business is known as Mwanja, but operation continues. That's why we are saying by order of the court without winding. So it's dissolved by the name, but also by the operations will continue as usual. So my dear students, another part of our revision is dissolution of cooperatives. Now this is very, very simple. This is very, very simple. Under this one, by a dissolution of cooperatives, dissolution of cooperatives. Under this one, when three-quarters of members have an opinion of winding up the business, we are talking about the registered cooperatives, which have been registered. When they come with an idea of dissolving the business, and the member is three-quarters, or 75% of members are in wish of dissolving the business, then such business will come to an end. Now the cooperative registrar will, and this should be in writing, will pass those documents, and he has to, or she has to be satisfied with those reasons which they have put in that paper. Then that business will be dissolved. Now let's come to different questions here. Question number one is, A company is legal person, but it cannot die a natural death like a human being. Explain different circumstances in which a company may undergo liquidation. So yes, a company may die. A company is a legal person, as we said before, is a legal person, but it cannot die a natural death. Now the question is, explain different circumstances in which a company may undergo liquidation. So here you provide different reasons in which a company may undergo liquidation. Or what are the causes of a company to undergo liquidation? Because under this question, the question is not stating whether compulsory liquidation or voluntary liquidation. So here, you have to write all the reasons, being voluntary reasons or compulsory reasons. So just make those reasons. The question is not giving any direction or any a direction of either is a compulsory or is a voluntary liquidation. So just give reasons. Question number 2 is, under what circumstances a court may give an order of winding up the company? Now you see, this is somehow different from the first question. Under this one, under what circumstances a court may give an order of winding? So a court is giving an order. So my dear students, try to think, when a court is giving an order, it means that this is a compulsory liquidation. So under this one, give those reasons which are for compulsory liquidation. Hope you have understood this question. And the last question is, elaborate different reasons which may cause dissolution of partnership business. So this also need you to explain different reasons for dissolution of partnership. So I leave this question as your assignment. Just pass through your notes, then you can see what are the reasons, and we have discussed these reasons here. So your assignment is differentiate between partnership, business, and partnership, business, and a company. So this is your assignment. Hope you have understood those 3 questions, and take these as your assignment to revise more on this topic of business unit. Thank you so much, and hope you have understood, and make sure you pass through these subtopics you have passed through, and do those questions, revise more questions, find other questions, and then you'll be very comfortable with this topic. This is a very, very important topic in your syllabus. So thank you. See you next time.